Hi, everybody. This is Steve Maggi from SMA Law Firm. Welcome to Building the Bridge. I have the honor and privilege of being with Chris Cavaliere today, who is a partner at Shoemaker Law Firm in Tampa and an expert in employment law. Thanks for being with us today.
Thank you so much for having me, Steve. I'm honored to be here.
So we've had some great talks in other videos, and we've talked about criminal background checks. And what I want to focus on today is really diving deeper into this. What happens when I do a criminal background check as an employer on a potential employee and I get a hit? What happens next? What can I do? What do I do? What's the best way to handle this?
Sure. Thanks, Steve. So I think in another video we dealt with the process and the rules that apply before you run a background check, right? And there are a whole lot of rules on that. Right now, I'd like to talk about, okay, now you've done the background check, you got a hit, you find out that this person has criminal history. And this is another area where a lot of employers can get it wrong, because it just sort of goes against common sense. Most employers think, okay, I did a background check, this person's got criminal history, I don't want to bring a criminal into my company. And they will just reject the job applicant, right? Without even thinking twice about it. And because that's sort of the common sense way that a lot of us would think about these things. The problem is that the EEOC, the Equal Employment Opportunity Commission, that's the federal agency that sort of oversees discrimination claims and those sorts of things. The EEOC sort of takes a hard line on the issue of criminal history and when can an employer reject a job applicant based on criminal history. And the argument that the EEOC has here is that minorities are arrested and convicted at rates that are disproportionate when you compare them with the general population.
Right.
So the EEOC's position is, look, if you're just going to reject a job applicant just because of the fact that they have a conviction on their prior record without doing any more homework, well, then that has the effect of discriminating against applicants on the basis of their race because of this disproportionate impact. Okay. So the EEOC has some rules when it comes to this thing. And just a little caveat here, what I'm about to say, I'm going to cover federal law and Florida law. Some states have their own rules when it comes to background checks and criminal history. But when it comes to federal law and Florida law, employers kind of have to stop when they get that criminal background check. They have to ask themselves certain questions. The very first thing, and this is the easier one to remember, is that the EEOC says, look, if you just find out that a job applicant had been arrested at some point, or maybe they were recently arrested, and that arrest has not resulted in a conviction, the EEOC takes a hard line on this, and they say, look, you cannot reject a job applicant just because they've been arrested, because the idea is you can get arrested for anything. It doesn't necessarily mean you did it. And minorities are arrested at disproportionate rates, yada, yada, yada. We talked about
and wrongfully convicted in many
and wrongfully convicted. Yeah. And we're going to get into the conviction side of it in a second. But when it comes to arrests, just an arrest, the EEOC says, you cannot reject a job applicant just because they have been arrested. Now, the employer can do their own investigation into the underlying conduct, into the conduct that led to that arrest, right? And if they determine after a reasonable investigation that the person actually did the thing that they were arrested for, and the thing that they did makes them unfit for the position for which they have applied, that's different. Then you can reject the applicant, but you can't just look at a report and say, this person was arrested, I'm rejecting the applicant. The EEOC takes a hard line on that. Even when it comes to convictions now, right? So we're talking about arrests that result in charges and that result in convictions. And keep in mind that there is I was a criminal prosecutor when I started out my career, so I know this by heart. An adjudication withheld or a withhold of adjudication is not a conviction. I just want everyone to remember that. But when it comes to an adjudication of guilt, when it comes to a conviction, the EEOC says that even then, even when you have a conviction, you can't just stop there. You can't just say this person was convicted of theft. We're rejecting this person. What the EEOC says is that you have to look at certain factors. What was the nature and severity of the offense, right? Theft can be pretty significant, right? Especially if it's grand theft or maybe a burglary, some other theft related charge.
Or it can be shoplifting, I guess, on the lowest
It can
end,
also
right?
be shoplifting, right? And then factor two is you look at how long ago did it happen? And all of these things tend to work together, right? And we'll see the bigger picture once we get all through all the
Is the
factors.
person rehabilitated? Did they learn their lesson?
Exactly. If someone was arrested for theft, or I'm sorry, was convicted of theft 20 years ago, and they have not had any criminal record since, there's a scale here, and it starts to tip in favor of, I probably can't reject this person, right? And then number three is another big one, and that's what is the job that they're applying for, and does the thing that they were convicted of have anything to do with the job?
Right. I was going
If
to ask.
they,
Sorry to interrupt.
go ahead.
If they qualify on all levels, I guess, right? Then that's where this comes up, because otherwise you could discard that potential person because they don't have the degree you were looking for, or the experience you were looking for, or whatever it might be, or the language skills, or whatever specific criteria you were requiring, they clearly don't have. If they have all those, then this is really where this comes up, right? If that's the only justification that you have.
Correct. And with only one small wrinkle that I'll put in there is that you just better make sure that if the reason that you're giving is the person's qualifications and not their criminal history, we need to be really sure that we've been consistent on that.
Okay.
Have we hired others who have had similar qualifications? Because if you have, then the person you're rejecting has an argument that, well, you really are discriminating against me because you hired these other folks. So we're going to assume that the person's qualified. And that the only reason why you're rejecting is the criminal history. Absolutely.
Okay.
So just to tie a bow on those factors, you kind of have to look at all three of those things. What was the offense? How serious was it? How long ago did it happen? And what is the job that the person's applying for? It's one thing if the person's working with children and they were convicted of some child-based sex offense 5 years ago, right? This is an almost definite reason that you're probably going to have a strong argument to reject the applicant. But if the person was convicted of retail theft, of shoplifting from a Walmart 15 years ago, and they're not going to be working with money, you got an uphill battle there. The EEOC might not like the fact that you're rejecting. They might say, well, wait a second, come on, we need to give folks a second chance. This person did their time, they paid their fines, they went on probation, whatever the case might be, maybe even jail time, and it's not fair to deny this person employment based on that situation. So it's very fact specific. One takeaway that I have, a little homework assignment that employers can do, is check your job application. I see employers go wrong on this a lot. A lot of employers will have just a really simple question on their job application, and it usually sounds something like this: have you ever been convicted of a crime? And that's it. And the person says yes or no. Now, some states, literally, you're not even allowed to have that question on the job application. Florida's different.
Okay.
But from a compliance and best practices standpoint, you should have a lawyer look at the question that you have that has to do with criminal history, because I can tell you when I help clients with this, the question is much more detailed than that. And there's usually some fine print saying that just because you've been convicted of an offense does not necessarily bar employment. Here's some spaces where you can give us more information about the offense, extenuating circumstances, etc., so that you're really showing that you're not just looking to deny folks just because they might have been convicted with a crime 25 or 30 years ago.
So, and that encourages the person to tell the truth, be upfront about it before they even go through that criminal records check, right?
And yes, and that's actually a fantastic point, Steve, because that gets to my second point about job applications, is that make sure that your job application has language somewhere in it where it says, I as the job applicant am certifying that everything, all of the information and documents that I provide is truthful. And if it's not, that's going to bar my employment. And the reason why that's absolutely, the reason why that's so important is because if someone lies to you on their application and they say, I've never been convicted of an offense, and you find out through a criminal background check that they actually have been, well, then guess what?
You have
You're
grounds,
now
you have justification. Yeah.
you have a justification. You're rejecting that person not just because of the criminal history, but because they lied to you on their application.
That's exactly what I was thinking would be the best thing to do. And that's the one time I've actually been talking to you, and I had an idea that made sense, because a lot of this to me is almost counterintuitive. It's a little daunting, especially for new employers. So how does an employer or a company, especially one that does not have experience with this, doesn't know that they need to dot their I's and cross their T's and watch every word that's in any of these application forms or documentation that they're sharing with a potential employee? How do they get in touch with you to make sure they're doing it right?
Sure. So you can call my direct line, 813-676-7208, or you can email me at cavaliere@shoemaker.com.
Fantastic. Thank you so much for your time and your knowledge today, Chris.
Thank you so much for having me, Steve. It's been my pleasure.